Now let's take a look at the homeowners insurance section 2 conditions. There are two types of conditions under a homeowner's policy. Those are conditions applicable to section 2 and conditions applicable to both section 1 and 2. Conditions applicable to section 2 apply to liability coverage, specifically to the policy provisions described in coverage E, personal liability, and coverage F, medical payments to others. Whereas conditions applicable to both sections can apply to both property and liability coverage and can be related to policy period, cancellation, non-renew, and other matters. One important concept is one occurrence. So if you have one insurance limit, you're going to have only one occurrence, and one occurrence will trigger one limit. If it is considered as two occurrences, then you will be able to trigger two limits. What would be considered as one occurrence? The exposures to the same harmful conditions will be considered to be one occurrence. For example, if your gardener becomes ill over a period of weeks after using a pesticide you have purchased, even though the occurrence has caused the injury was not a single event and it has took place over several months, the injury will still be considered as a result of one single occurrence because that's the exposure to the same harmful condition. However, the coverage F, medical payments to others, is defined a little bit different. So one limit is applied to one person instead of one occurrence. So normally, if you have two people become ill or become injured at the same event, it will be considered as one occurrence. However, under the coverage F, medical payments to others, two people becomes ill or becomes injured at your place for one incident, that would be considered as two occurrences, and that's why two coverage limits will be triggered. For example, an insured with $1,000 limit for coverage F would have $1,000 in coverage available for each guest injured in an accident at the insured's house. The severability of insurance is a policy condition that applies to insurance separately to each insured, and it does not increase the insurance company's limit of liability for any one occurrence. So under the severability of insurance, multiple insureds covered under the same homeowner's insurance policy will be treated differently, and if he or she has separate limit, as if she or he has a separate coverage under the policy. However, the policy will not exceed any of the limit that it has defined, but it will cover a claim brought by one insured against the other insured. The duties after occurrence under Section 2 is very similar to Section 1 duty in a way that you also have to give written notice as soon as possible. You need to cooperate with the insurance company's investigation, settlement. However, some additional duties includes your cooperation with the settlement, the defense activities, and also you have to forward legal documents properly to the insurance company and provide claim assistance to the insurance company in making the settlement, enforcing any right of contribution against the other party, attending hearings, trials, securing and giving evidence, and obtaining attendance or of witness. After the occurrence of the accident, the insurer's duty includes several requirements. Again, you have to submit evidence for the damage to the property of others when a claim is made. And also, you don't want to make any voluntary payment, and that's the same principle as you have under the auto insurance. There are certain duties for the one who has been injured, and that triggers coverage F medical payments to others. Now, you may still remember that medical payments to others is not necessarily a liability coverage because the insured need not to be liable. So the medical payments to others is there so that the insured can fulfill his moral obligation. So the injured person, however, must still fulfill the requirements such as give the insurance company written proof of the claim as soon as possible, authorize the insurance company to obtain copies of medical reports and records, submit a physical exam by a doctor by the insurer as often as the insurer requires such examinations. So all of these conditions are there to secure that there is no moral hazard problem. So the injured person is not trying to get money from insurance company based on something that he did not suffer. However, even though medical payments to others, the coverage F is triggered, does not mean the insured is liable for the loss because, as we said before, it's just to fulfill the insured's moral obligation. Our previous example was if your guest have cut himself with a knife when he's trying to cut a watermelon for you, and you could trigger the coverage F medical payments to others to pay for his injury because you feel sorry for him. However, it doesn't mean that you are liable for his cutting himself, given that he's an adult. So the intent of this Section 2 medical payments coverage is to prevent suits or to reduce the damage resulting from possible claims by providing a prompt payment for the injured parties, but it's not there to admit there is a liability. Sometimes you have seen the cases where the insured sue the insurance company for the money that insurance company refused to pay. However, you have to bear in mind that the insured can only sue the insurance company if they have fulfilled the following requirements. First, he would have to meet all of his obligations, and the insurance company cannot be joined as a party to any action against an insured, and the obligation of the insured has been determined by a final judgment or agreement signed by the insured. Of course, if you have committed a fraud against the insurance company, you cannot get coverage from your insurance anymore. However, in the case when there are several insured under the same policy, one insured committing a fraud, condition that the other one does not know about it, would not prohibit the other from claiming from the insurance company. So in another word, the innocent insureds would not be excluded from the liability coverage. The bankruptcy of an insured condition says even though the insured may declare bankruptcy, the insurance company still needs to pay as it normally would. If you have other insurance, the other insurance condition will apply. It either pays as an excess, or it can be some other payment if it is written in the policy. The policy period condition says the coverage only applies to any bodily injury or property damage that occurred during the policy period. However, the claim can be filed even after the policy has expired. The liberalization clause says that if an insurance company wants to broaden its coverage on a new and renewed policies, the current policies of the insurer will receive the broader coverage as long as there's no additional premium related. Suppose that in order to attract new customers, an insurance company will provide replacement coverage on contents to all insureds at no additional charge. On the date of the additional coverage becomes effective, all existing homeowners policies issued by the insurer automatically will be included with the additional coverage, even if the insured are not aware of the change. The policyholder may cancel the policy at any time by returning it to the insurance company or by contacting the insurance company in writing and advising the insurance company of the date when cancellation is to take effect. The insurance company, on the other hand, can also cancel the policy, but only for certain stated reasons, which is determined by every single state regulation. And after that, the insurance company needs to deliver a written notice of cancellation to the insured within the stipulated number of days. If the insurance company do not want to renew the policy, it needs to provide at least 30 days of written notice to the insured if it does not plan to renew the policy. Some states require longer period of notification, but the non-renewal notice can be mailed to the address on the declaration. Another condition will be the waiver of change of the policy provision. Waiver is the intentional relinquishment of a known right. A waiver or change of the provision condition states that a waiver of a right or change of a policy provision is valid only if the insurance company makes it in writing. If we don't have this condition, then there can be a parent authority. A parent authority is a third party's reasonable belief that an agent has authority to act on the principal's behalf. If the policy do not have the waiver provision, then the court can permit the use of oral waiver by claims representative made during the adjustment of a loss and after the written policy was issued, because the claim representative are the insurer's representative and have the apparent authority to modify the policy condition. On the other hand, an insurance company's agent will have the binding authority, and they will be authorized to make policy change through an oral binder that is effective until a written policy change endorsement is produced. As has been said above, the waiver or change of policy provision states that the insurance company's representative cannot modify the policy and relinquish a right unless the insurance company does so in writing. Otherwise, court will permit any oral waiver made by a claim representative or an agent. The insurance contract, the policy, is a personal contract between the insurer and the policy holder. And therefore, the insurance company must be able to choose who it will insure. So the assignment condition states that the insured cannot assign the policy to another party without the written consent of the insurance company. Let's use an example. When you buy a house, the homeowner's insurance does not come with the purchase of the house. Instead, the insurance company has to underwrite the new homeowner separately. Subrogation stipulates that an insured can waive all rights of the recovery against another party. However, they must do so in writing before the loss occurs. So subrogation is in the absence of any pre-loss waiver, the insurance company can require the insured to assign all rights of recovery against another person to the insurance company to the extent of the insurer's payment of loss. Here is an example. If you have a homeowner's insurance that covers your house, if your neighbor's tree fell onto the roof of your house and damaged it, and it cost you $10,000 to fix your roof. Since you had the homeowner's insurance, and this is considered as one of the covered loss, your insurance company will pay you the $10,000 to fix your roof. However, at the moment the insurance company pay you, they will have the right to sue your neighbor. So they can sue your neighbor and perhaps get $10,000 back. And you will not have any right to the $10,000 your neighbor has paid for the insurance company. And what the insurance company is doing is to exercise their subrogation right against your loss. The death condition stipulates that if the named insured dies, the insurance company will cover the descendants representative as an insured. So if the homeowner dies, his legal representative or his son or daughter, whoever is going to inherit the house, will be automatically covered under his homeowner's insurance. So far, we have been concentrating on the HO3, the broad form coverage of homeowners insurance. As you can imagine, there are some other homeowners insurance forms. For example, if you don't own a house but you're renting apartment, that you could cover your personal belongings inside of that apartment with the apartment dwellers insurance coverage HO4. Similarly, if you own a condo, you don't necessarily own the entire condo because you could be sharing your roof, your walls with your neighbors, and therefore you don't have an absolute ownership to those properties. And the condominium unit owner's insurance policy, the HO6, would cover that loss. On the other hand, if you don't want to have that broad coverage, which gives you open peril coverage form for the house, the other structures, you could have it covered under HO2, which is the basic form, which is the broad form. The HO3 is the special form. So some customers will accept more restricted coverage, and in exchange, they get a lower premium. So HO2 provides named coverage to all of your properties, including your house, other structures, and your personal belongings. But HO3 is a special form that provides open peril coverage for your house and other structures, but it provides a named peril coverage for your personal belongings. However, what about someone that also want an open peril coverage for their personal belongings? In those cases, they could choose HO5 with the broadest coverage. However, they will have to pay more. What if you own an older house and that house may be depreciated substantially and will not well suited for the replacement cost coverage, which is for the HO3 coverage? In that case, you could modify it using the HO8 coverage. As you can see, the main difference between HO3 policy form and other homeowners insurance form is actually the Section 1 property coverage. For example, if you're owning a condo or you're only living in an apartment, you may only have the personal belongings instead of that property covered, and you could choose HO4 and HO6. And if you want to have a limited coverage, you could choose HO2. If you want to have more coverage, broader form, you could choose HO5. And if you live in an antique house that has been depreciated substantially and you don't want to have it covered under the replacement cost, you could use the HO8. However, the liability section does not change dramatically. As you can imagine, it doesn't matter what kind of house you're living in. Your liability is perhaps similar. So if you have a pet that can hurt people, a very aggressive type of dog, it doesn't matter what kind of house you're living in, your liability is still being exposed. So if we compare the broad form HO2 coverage with the HO3 coverage, the difference will be how the perils are covered. The HO2 covers the dwelling, other structures using a named peril coverage. So it actually covers fewer causes of loss. For example, it does not cover theft. However, the HO3 uses a broad form coverage, and it provides an open peril coverage. And therefore, as a consequence, it has a slightly lower premium than the HO3 with the similar limits. And since the HO2 has a broad form coverage, which is the named peril coverage, the homeowner will have to prove that the loss is indeed the covered loss. With the HO3 coverage, the burden of proof has shifted to the insurance company because it's an open peril coverage and it basically covers everything in the universe. So that the burden of proof is now on the shoulder of the insurance company, so that the insurance company will have to prove that this is indeed one of the exceptions that will not be covered. The other side of the coin is the HO5 comprehensive form. As we said before, it uses an open peril coverage for your personal properties. In addition, HO5 covers some water damage, including flood damage, for personal property away from a premises or location owned, rented, occupied, or controlled. HO5 also covers personal property damage by rain through an open window, door, or roof opening. So we said in HO3, if your property is damaged inside of your house by rainwater, you will have to prove that the rainwater has gone through your window, which is a closed window. So you do not cover negligence. However, HO5 covers somehow negligence because even though it's an open window, it will still be covered. HO4 is what we call the content broad form. So it only covers whatever property you have inside of that apartment. It does not cover the apartment itself because it's the renter's insurance, and renters don't have any ownership to the apartment. So it differs from the HO3 in the following ways. First, HO4 coverage C is written as a limit, as opposed to HO3, which is a certain percentage of your house value. And the second difference is the coverage D in HO4 is provided automatically as 30% of coverage C limit instead of the coverage A dwelling limit. The third difference is the HO4 provides additional coverage for building additions. So for example, if you are a renter, but you just don't like that old carpet in the apartment, so you have decided to tear up the carpet and put in a new hardwood floor on it. Now you would have some partial ownership to the hardwood floor. So during the time you're renting the apartment, you will have that ownership to the hardwood floor. So HO4 would provide additional coverage for those kind of additions. One example would be what we've just talked about, the floor. If you're handicapped and the new ramp you put at the house so that you could get access to the house would also be covered as additional. Finally, both HO3 and HO4 provide additional coverage for ordinance or law. The HO3 limit is up to 10% of coverage A, since HO4 do not really have coverage A, so the limit is 10% of the building additions and alteration limit. The condominium or cooperative units are some housing unit in a complex owned by a corporation, the stockholders of which are the building's residents. The corporation owns the real estate title. Each unit owner owns corporation stock and has the right to occupy a specific unit. So as you can imagine, since you don't have the ownership to the entire building, you cannot have it covered under a policy. So the HO6 is very much similar to the renter's insurance. However, HO6 is a little bit different. There is a condominium ownership deed instead of having no ownership at all for the apartment. So the condominium ownership deed is called a condominium declaration or a master deed. Usually contains insurance requirements and describes the insurance provided for the jointly owned property, which is called the condominium association insurance or the condominium master policy. With that policy, if your roof has been torn up by the tornadoes, now even you don't own that roof, that master policy will be triggered to pay for your roof, and therefore you don't have to pay for it, you don't pay to fix it, but the master policy fix it because your roof is not just owned by you, but it will be owned by the entire condominium association. However, the property that is not owned by this insurance is usually the individual unit's owner's responsibility, and therefore you could use that HO6 to cover that. The difference between an HO6 and HO3 are the following two ways. Here are some specific differences between the HO6 unit owner's form and the HO3 special form. First, it has a different definition of the residence premises. The HO6 defines the resident premises as the unit where the insured lives. The HO3, however, defines that 1 to 4 family dwelling would be considered as dwellings. And second is the ownership difference. For coverage A, the dwelling coverage, HO6 covers alterations, appliances, fixtures, and improvements that are part of the building contained within the insured's unit. And that would be your fridge, your wash and dryer, your new hardwood floor put in, and the painting and the ceilings, everything you have changed when you have moved in that unit. It could also cover the items of real property that pertains exclusively to the insured unit. That could be your AC unit. It also covers the property that is the unit owner's responsibility under a condominium cooperative association's property owners agreement. And the structures owned solely by the insured at a residence location. So for example, if your condo is a 2-story condo, that only your wall will be attached with your neighbors. So the floor between the first floor and the second floor will be considered as your own property. However, if you're living in a condo where your neighbor is downstairs, then that floor between your and his ceiling will be considered as owned by both you and your neighbor, and that's why it would be considered as the whole condominium association's property. So the coverage A dwelling is different, so that the HO6 policy provides a basic limit of $5,000. As you can imagine, it's not really much when you compare that with the house value. And the coverage B other structures is eliminated from the HO6. So you cannot have that clubhouse owned by the whole condominium association covered as coverage B. And thirdly, the personal property coverage is very similar. Coverage D, the loss of use, is not going to be a percentage of coverage A, but it will be a percentage of coverage C because you don't have much coverage A coverage, right? So you're going to have a limit of 50% of the coverage C limit for the loss of use. And the Section 1 perils insured against will be a named peril basis for coverage A and C, which is similar as the HO2. HO8 modified coverage form is designated for those houses that are older and the structure is hard to fix. So where the replacement cost of the owner-occupied dwelling is significantly exceeding its market value. For example, if you own an older house with obsolete construction or features that could be very expensive or even impossible to replace, such as hand-carved wooden moldings with market value of $100,000 but rebuild cost of $200,000. In that case, the homeowner shouldn't purchase an insurance with $200,000 due to the potential moral hazard problem. Because, for example, if you sell the house, you can only get $100,000. But if you burn it down to rebuild it, insurance company will pay you $200,000. In that case, you will have an incentive to burn it down, right? So HO8 can use the functionally equivalent as a compensation basis.